My name is Kyle Ingram. I'm an attorney in Washington, D.C., and I help out federal employees with discrimination matters. I wanted to do a Q&A session just to answer some questions that have come up in a few different contexts. And one of the most common questions that comes up for me is, should I request a hearing before the EEOC? I can't answer that question specifically for everybody's circumstances, but I can definitely provide an approach to start thinking about how one would answer that question. So the first part of this is to figure out what's the benefit of having an EEOC administrative judge and the process that comes with that. So the administrative judge process, right? You file for the hearing, you go in front of a judge, the judge will typically order discovery. Discovery is an opportunity for you to get additional information from the agency or to submit additional information that either didn't make it into the ROI or has come up since the ROI. You can also take depositions of key witnesses. So, for example, if you need to prove discriminatory intent, that frequently is a sound basis for requesting discovery, because otherwise, how are you going to prove the discriminatory intent of the individual? It can be done for sure, but the question is still there, right? It's a complex one, and the agency has a very low burden typically in an intentional discrimination case. So if you do request a hearing, these are all things that you get from that hearing process that you otherwise wouldn't get from the other process that happens if you don't request a hearing. So if you don't request a hearing, what happens then? If you don't request a hearing, or you don't request it within the 30-day time limit after you receive the report of investigation, what happens is the agency then forwards your file, your report of investigation, to the specific EEO adjudications office within the agency to issue what's called a final agency decision. Their decision, from the perspective of the agency, is final unless you appeal it to the EEOC. So you don't get any opportunity to submit new documentation. You don't get any opportunity to get additional documentation from the agency. It's based solely on what's in the report of investigation. So that's between those two choices, the open question would be, why wouldn't you request a hearing? Right? You might say, if I request a hearing, it's going to take a long time to get an administrative judge. I'm going to have to go through discovery. I don't want to get an attorney because I probably need an attorney to help me with that. Those are all fair considerations. On the other side, if I don't have the opportunity to get additional evidence, do I have enough evidence to be able to prove my case? That's a complex question. That's a very complex question, and one that you may not really be able to answer. In the absence of any other considerations, one might reasonably think that it was always a good idea to request a hearing before the EEOC unless there's a good reason to do otherwise. And here's why one might think that, because if you do file a request for a hearing, you can withdraw that request later. So that makes it very easy to go one way on one path towards EEOC hearing, and then to switch over to the other path and request a final agency decision. If at some point you determine, no, I don't want to have an administrative judge, this is not the path that I want to pursue, you can simply withdraw your hearing request. The opposite is not true. If you decide on a final agency decision and you change your mind later, you cannot request a hearing after that 30 days has expired. So up to that 30 days, you can change your mind. After that 30 days, you can't. Whereas, as I explained just a moment ago, the opposite isn't true. If you request a hearing, you can withdraw your request really at any time. And there's nothing in the regulations that penalizes you for doing so. And then it will just go to a final agency decision anyways. The loss in that circumstance where you've withdrawn your request after going down that path is really just the time that you've spent and the energy and possibly the money in responding to all of these requirements from the EEOC administrative judge. But that, in a nutshell, is how to think about and how to approach the question of, should I request a hearing, so that hopefully, if you're considering that question, that provides you with at least an analytical approach to understanding how you might answer that question.